Or I'm gonna here. I'll meet you here. There we go. Okay. All right, there we go. Hey, look, we're on time this morning. Fantastic, and this is going to be a fantastic episode. There's really nothing quite like it. Well, there's nothing quite like Irishmatic, but there's not a lot of content on this incredible topic. And I was actually looking for some information just to sort of support what we're going to be talking about today. Because really, and here, let me get out. If you're not familiar with this term, I think this is incredibly helpful. And it's called, let me get to it, the Great Wealth Transfer. The Great Wealth Transfer. I haven't heard about this before, but here's the story. Here's the scoop that we're getting to. Baby boomers are the wealthiest generation that have ever lived, accumulating money and assets over their lifetimes. During their lifetimes, they experience rapid evolutions in modern medicine, changes to the political landscape of the world, and incredible innovations in technology that they were largely responsible for driving. In the United States, baby boomers account for 51.8% of the country's total wealth, net worth $78.55 trillion. However, as we get to, this baby boomer population is aging. As this baby boomers pass away, the wealth they have spent their lives amassing will be passed down to their children. And that's part of what we're talking about today. What I was looking for, in addition, was an article that explained the global implications of the Great Wealth Transfer, because two things have happened. We have, number one, there are more U.S. expats with assets globally than ever before. And I would say most of my clients, probably 80% of my clients, are baby boomers. So that is a huge thing that is different, totally different. And no one seems to be talking about it. The other part of the equation, we have, right, Keith? And the other part of the equation is this. There's immigrants in the U.S. with assets globally. So, Keith Redmond, good morning to you, my friend. With me, I'm Anthony Parent, your host of Irishmatic Channel. And with me today is Keith Redmond and John Richardson. John is coming from, he is traveling today, but he wanted to meet today because this is so important. We're going to be discussing today, and no one else is covering it. And again, Keith Redmond, this is Keith. This is huge for you and your group. Good morning to you, Keith. How you doing?
Hey, good morning.
So, and I think you and Keith, you said you have to hop off this call. You have to hop off this podcast at 8:20 today. Why is that?
Well, because I'm going to be talking to a couple in Eastern Europe, and one of the issues is inheritance coming from the United States. From a parent. Yeah.
Yes.
And it's interesting because when inheritance comes up, it's either I'm talking with a baby boomer or the child and sometimes grandchild of a baby boomer. So this is quite appropriate.
And thank you, Keith. Yeah, thank you for that, Keith. And it is really something that is coming up, and we're handling more and more of these issues as people figure out. Wait a second, and oftentimes, what's happening? Someone's going to inherit something, and like, hey, look, we got to get into U.S. tax compliance because we're going to have problems if we don't.
Right? Because as you know, Anthony, I have that other angle because I deal with people who have either never been in, or they have not been in for a long time, the U.S. tax system. Yeah, and they don't know what to do and what their options are, et cetera, et cetera. Yeah.
Right on. All right. Well, I know John is traveling and he's doing his best to hopefully he has a good connection. I do want to get because we've covered tax treaties all the time. We've covered tax treaties multiple times, particular treaties on particular things. But one thing we never covered, and I realized this, we never covered estate and gift tax treaties. And I'm thinking to myself, wait a second, this is insane. We never covered gift and estate tax treaties. At the time, it's going to be the most important beyond. And I mean, there are going to be there. This is going to be, I would imagine, the greatest growing legal field, international estate tax planning and probate. In my mind, I can't think of a bigger growing field for the next 20, 30 years because of all the things that we've encountered over the years. And let me just check in with John. Hopefully he can get into it because he did a great presentation. There he is. John.
If I may just interject one thing, and this is for John, maybe to explain to the layperson the difference between a regular tax treaty and a gift estate tax treaty. What's the difference for people to understand?
Well, I think we're going to get into that, right, John?
Yeah.
All right, John is doing his best to come in where he is. He's got a little bit of background noise, but that's right. The content is going to be great today. I went through this today, so John's going to explain this. Good morning, John, or afternoon, wherever you are. Are you moonlighting as a toll booth collector?
What's that?
Are you moonlighting as a toll booth collector?
No, I'm cycling.
That's what it looks like.
Oh, you're cycling. Oh.
Shall I take this off? I can take off the video.
No. I just wonder. It's wonderful. This is the dedication to the craft, John. We appreciate it. Coming live whenever is required. So you're pulling off the side of the road on your bike trip to talk. This is wonderful. I love it. This is great. So John, let's get into I don't know if you want to handle John Keith's question now, or if you want to get into sort of, what is the difference between an estate and gift tax treaty? I guess we're going to get into that right now and kind of get into that, right? I mean, that's probably going to be our first slide. So here we go. Oh, well, here we go. I think this is John's. John is wonderful at getting us to look at the structure of the statutes as they are. And yes, I can hear you in my head, Andrew. I can hear you in my head. I know. We'll get to that later. John does a great job. And this is where I think is a great explanation of this. John actually just goes to the code and says, here's the structure of the code. The code is defining the differences itself. And as this is fun. So John, here you go. This is our first slide that we have. So where do we find, we have the code. I should really let you speak. This is your presentation.
Well, I mean, obviously, the difference between, it's visually evident, right? I mean, the difference between an income tax treaty and an estate tax treaty is the difference between Subtitle A of the Internal Revenue Code that deals with income tax and Subtitle B that deals with estate and gift taxes.
There we go. All right. That was pretty simple. A little bit more to that. Now, as you're going deeper into it, well, what is exactly Subtitle B, right?
So Subtitle B. Okay, let's back up a little bit. Okay, when we talk about taxation generally, the world and obviously this channel is very obsessed with income taxes, and income taxes. The obsession with them is because they're so horrible and so complicated and that sort of thing. Many countries have all kinds of different kinds of tax. I mean, if you just go back a slide and look at the structure of the Internal Revenue Code, you'll see all kinds of different taxes. There's an old, what was I think intended to be a joke I once heard, although I don't think it's all that funny. The United States taxes only one thing, everything. And the truth is that, that the United States has most of these different kinds of taxes. I mean, they would argue they don't have sales taxes, but, very clearly the tariffs on foreign imports are sales tax on foreign imports. So, the point is that there are all kinds of different taxes, right? And estate and gift taxes are probably the oldest form of tax, and they should be thought of as transfer taxes. They're just a tax you pay for the privilege of dealing with your property, as you want, sort of thing, right? So that's what this is about. I think that most countries seem to have gotten rid of them. At least in terms of their being in a separate part of their tax legislation. I think the United States keeps them just to give lawyers something to do.
That does seem that way. Well, we're going to, there is definitely something that I think I agree with you on. I mean, yeah, I totally agree with you on that. And really, a lot of the compliance industry is defined by the lawyers. The cartel, the private association. Yes, Andrew, I could hear you in the back of my head. Yes, I know. I'll get to that later. I'm sorry. I am my common law friends, which have been attracted to this site, which have really gotten me think that's what's going in my head constantly as we go through this. And I will get to your questions as we get to this and sort of the explanation. But we want to get to the content and actually the law as it is now. That's what we're trying to get to right now. Okay. Here we go. All right. Well, there's only three. Hey, look, there's only one thing the U.S. tax will tax everything, and there's three kinds of people, I guess. So explain these people, how they impact the taxation here, John.
Yeah. So, we start off with citizens, right? The general rule is that if you're a U.S. citizen, you're going to be hit with the full force of any and all of this stuff. And that's certainly true here, right? So if you're a citizen, you're subject to the estate and gift tax regime in its totality. And that includes non-U.S. situs assets, by the way, okay? Worldwide assets. Now, in the income tax, right, we have resident versus non-resident. The statutory language in the estate and gift tax part of it, subtitle B, retains the difference between resident and non-resident, but the way resident is defined is very different. And it's in terms of domicile, which we'll talk about. So if you're not a citizen, the second category would be, say, a green card holder who lives permanently in the United States and therefore would be domiciled in the United States. And the third category would be somebody who's not a citizen, not domiciled in the United States, but has the misfortune of having U.S. situs assets, which leaves them open to extremely brutal and confiscatory taxation.
And I want to get to that in a little bit, but not right now. But I think that bears incredible importance because exactly you're right. So we'll get to that. And John, I'm making a note of that to make sure we hit on that. Keep going.
Those are the three kinds of people.
All right. Those are
mostly when you read about this stuff, people put it in two categories, right? Citizens, residents, okay, versus non-residents sort of thing. But it's really three. It's very, very interesting how the U.S. maintains this citizenship classification. And not all estate and gift tax treaties use that kind of language. All right, and again, there's U.S. obsession, right, with citizenship as a basis for taxation. And that's something that I think might be a useful blog post, article, and or podcast, right, down the road. But in any case, moving on.
So citizenship-based.
It's the kiss of death.
Yeah, right. Yeah, right. Now.
Citizenship is the kiss of death, okay,
and I think
when it comes to U.S. taxation.
And I think, this is exactly why, we really greatly appreciate you because you're correct. Most of the tax industry will just say there's two kinds of people, but no, it's wrong. There's three. And it's really that number three is one. And that's the one that can get really, really bad. And well,
Anthony, number one can be pretty bad. Okay. Yeah. If you're taxed on your, if this applies to your non-U.S. situs assets, right?
That's true too.
I mean, we'll get to that in a minute because it seems to me that there are strategic issues, right, in terms of whether to renounce or not.
All right, we're going to get into it. All right, fantastic. Okay, all right. Now we have two kinds of assets. Tell us about the two kinds.
Yeah, well, do I get an award for simple-mindedness, Anthony?
You are getting so many gold stars today. I would say that the simple-mindedness, you explained very quickly the difference between subtitle A and B, where we go to the gift tax. And so, we've really been following along quite logically and simply so far. I think people are really going to appreciate it because I think we're probably going to dive off the deep end a little bit soon as well.
All right. So three kinds of people, two kinds of asset classes generally, right? So you can think of this in terms of stuff that's located in the U.S. and stuff that's not located in the U.S. The technical language would be U.S. situs assets and, versus non-U.S. situs assets. And obviously, okay, if you are a non-citizen, not domiciled in the United States, your concern is only with U.S. situs assets, okay? U.S. situs assets.
All right. Very good.
So, I mean, just to make it real simple, okay, close your eyes and imagine a small shopping plaza located in the United States versus a small shopping plaza located in, say, Canada, right across the border, okay?
Right. That's right, exactly. Yeah. All right. So all right. Next slide. All right. Now we get to this one, meaning of domicile.
Now, this is really just indescribably important, okay? And it's funny, I hadn't even thought of this till I started talking today, right? But and somebody ought to check this, but I'm pretty sure the statute itself uses the word residence and not domicile, right? So what's interesting, now here we go, right? What is fascinating I mean, really fascinating, is that the meaning of residence is defined by regulation, not in the statute. Now, think about that for a minute. Okay? The statute doesn't, in and of itself, doesn't define what it means to be a resident versus non-resident. It's the regulation that does that.
Wow.
And I think that is practically criminal.
And I also, you know what, and there's an issue right there, because there's another challenge that could come up, because we have major policy decisions cannot be decided by regulation, but really, and then every law must be clearly defined. So that could have a constitutional problem, like most of the code. It could have.
Well, it's really interesting. Now, of course, the counter to that would be, well, everybody knows the regulations are essentially part of the statute. I get that, but the issue I have with this stuff is this: that I cannot understand about 85% of it, okay, without making an effort to actually understand it.
Yeah.
If you look at stuff online, you'll find all kinds of snippets, this, that, right? And there is no way to understand it. This is the problem. Because it's just not, the only way to understand it is to kind of learn it in totality from the top down. I mean, I've talked to so many people over the years, they say, well, if I'm making a gift to my foreign spouse, for example, I can only make a gift of $190,000 a year. Where do they get that? Well, they get that from something off the IRS site. But that's not true at all. Okay, you can make a gift of, any amount you want. It's just that the first $190,000 operates outside the gift tax regime. That's all. But there's no way to understand this. This is the problem.
Right.
And I've begun to.
Yeah, if I could just, Keith, I want to check in with Keith to make sure he's following along. And Keith, this is something that we learned in law school. Like in law school, this is one of the, in civil procedure, I believe it was a class we did. We debated. Well, what's a domicile? What's a domicile? How do you know where someone lives? And it's like, well, it's a multi-factor test to determine blah 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 blah. But essentially, what it will come down to is, well, what's the intention of the person? What's their intention? And you end up with these absurd things of like, well, there's no evidence of their intention either way. Sometimes like, well, they're just saying it. It's like, well, if someone says they're domiciled, then they're domiciled, and if they're living there. But the whole point is that you need to, there's no way to take an MRI of someone's brain to say, hey, where do you intend to be domiciled? It's always the facts and circumstances test of what it is. And so this is why I'm sort of like looking at this, like, I didn't know that domicile was defined by regulation. To be honest, I didn't know that. But that goes, again, further and further, where these incredibly important, law school debates that will go several days and will be on the test. And these are things that are decided by regulation. So does that help you explain why my reaction to this, like why it's so dangerous to have regulations define things that should be defined by law and that were specifically defined by the common law? Keith, did you hear my question?
No, I mean, I was listening to you just about domicile. What was the question, please?
So and I just want to make sure you understand why we're harping on this, because in law school that we spend a great deal of time defining what domicile means in various ways, and just not in tax consequences. And it's really a common law facts and circumstances test is really what it is. Like, well, look, it's defined by someone's intention, and it's a very, kind of older test. So it's the common law that is where we got our domicile. But in this case, we have domicile not defined by a statute, which is probably bad enough as it is, but it's defined further by a regulation. Something so critical is defined by something no one ever voted on. Do you see the point now?
I see the point, but I guess I have to ask a question.
Yes.
And forgive me if it seemed to have been answered, but being the layperson here, what is the difference between domiciled and resident? So let's say I'm domiciled in France. I'm a resident in France. What's the difference between those two statements?
Perfect question. The only difference, and this is the point, is intent. The intent. Because you could have the very same exact facts. Well, I live in Florida. Well, how do we know you want to be domiciled there? Well, I intend to. Okay, and that's really what it comes down to. So it's really the intent. So we're again talking about something completely subjective up here in the brain that we can't objectively measure. So we look to outside circumstances to infer whether or not that person intended to domicile there. That's really the
Okay.
yeah.
Yeah, now that makes sense because a few years ago, not to go into the details, John helped me with a situation where he gave me some statements to prove that I was domiciled in France. And so that
Ah,
really helped. It was based on circumstances. So
correct.
okay, got it.
Right. And so and here we go. A person who acquires domicile on place by living there for even a brief period of time with no definite present intention of later removing therefrom. And so they define it in a negative way. They define it in a negative way where they should say a person acquires domicile by intending to make it their domicile. Right. That's what it should say. But they're like, well, we're going to define it as a negative. And then they further go, residence without the requisite intention to remain indefinitely will not suffice to constitute domicile, right? And that's where they're saying
Yeah.
it's nor will intention to change domicile affect such change unless accompanied by actual removal. So if you want to change your domicile, but you're still there, but you haven't done anything, well, that could still be your domicile. So the problem is this, is that we get into facts and circumstances to determine where your domicile is, and a court could rule you're domiciled when you're not, and the circumstances can be, and the consequences can be incredibly
Right.
so here's
Devastating.
the danger.
Yeah.
It really, here's the danger. And who is the one deciding where you're domiciled? Well, it's the IRS. And currently, as it is now, if you go to tax court, it's the IRS reviewing the work of IRS to determine that they did everything correctly. So, that's really one of the problems we have. All right, that's an important thing. So I needed to spend a little bit of time on that. It's a really big issue. So let's move on there. All right, so let's get to this, John. Let me get you back up here. All right, thanks. There you are, John. Thanks. All right. So here we got the state and gift tax applied to non-citizens.
That's right. So again, if you're a citizen, that's it. Okay. There's nothing more to look at. If you're not a citizen, then the domicile thing is the issue, right? Now, let's see here. I can't even see the screen because I'm on a phone.
All right, so
but I mean, I think that pretty much covers that, doesn't it?
A resident decedent is a decedent who, at the time of death, had domicile in the United States. Okay,
a resident would be somebody who died intending to live permanently in the United States, right? And understand, okay, that this could be a resident who moved back to another country and was still living there at the time of his or her death, right?
Yeah. Now I'm going to ask a hypothetical that might kind of get the clarification here. Okay. So as we talked about before, we mentioned before, there's an entirely separate estate tax when you are a non-U.S. person with U.S. situs assets. And as John has on the slide below, you see the situs assets over $60,000. It's a pretty horrific estate tax. People forget about this. So the question I have for you, John, let us suppose that someone is a non-resident, I guess, or they have U.S. situs assets. In this pattern, someone lived overseas, but they have U.S. situs assets. They got wind there's an estate tax. So they didn't make a plan, but in order to avoid the lower threshold of the estate tax, and they want the U.S. resident estate tax of $15 million and not the one of $60 million. What if they move to the U.S. with the intention to be domiciled in the U.S.? Would that now trigger them from being a non-resident to resident to get that better tax treatment as a resident with the $15 million exemption?
Well, yeah, sure it would. In theory, it would. I mean, you've got to make sure, obviously, that factually everything lines up. But yeah.
All right. So there you go. There could be something. And that is the kind of thing. And now you can see, folks, this is why we're trying to say the intention of your domicile can be so critical, because that is a fact and circumstance that will go to your mind, your state of mind. And if the U.S. government decides, like, hey, no, we're not, we're not going to, and your difference can be substantial. Let me just do some quick math at the top of my head. Let's say you get $10 million. if you have $10 million,
Well, you don't need to do the math, Anthony. Okay, you just speak with broad brush. You're going to lose. You're going to lose 40% of your assets. Okay, the 60,000 is so trivial; it might as well be nothing. Okay,
thank
the
you.
way to think about this is you lose 40% of the assets, or you keep it. Okay,
There you go. Right.
if we get into the arithmetic, it's going to divert from the real issue.
And that's right. So I do like math though. Can I just give a hypothetical? So if you had $10 million, you would be left with $6 million. Your heirs would be
they'll take $4 million. That's right.
right. And but if you're a U.S. resident, it would be zero. So wow, what a swing! Zero versus $4 million. Zero versus 40% confiscation. That is a huge thing, and that's a big effort. So that's one way around it. There's other ways too. You could still remain a non-resident. There's ways to plan it. There's actually pretty simple things you can do to avoid that. Unfortunately, not everyone's getting that memo. All right. So next slide we got here. All right, now this is always something we discuss a lot. We've done some podcasts. A family that renounces together stays together because we discuss this common difficult problem, the covered gifts. And so, John, explain this slide to us a little bit here.
Well, I don't think we're even on the level of the covered gift yet. I think that this is a very strategic issue in terms of whether to renounce U.S. citizenship or not. Because look, if you renounce U.S. citizenship, remember that you lose your right to live in the United States in general. I mean, you can get a visa to go back, but let's assume it's somebody permanently outside the United States. You're going to become a non-resident alien for income tax purposes, and we understand that can have major consequences, particularly for low-income people living on Social Security, right? If the U.S. retains the taxing rights to that, because they'll be taxed differently. But on the estate and gift issue, it's quite interesting because if you renounce and you become a non-citizen who is not domiciled in the United States, right, which would be the operating presumption with renunciation. I mean, if you had small apartment building worth, to use your example, $10 million in the United States that you didn't want to sell, would that affect your decision to renounce U.S. citizenship?
I was just going to ask you that. That's exactly right. Yes.
Absolutely, it would.
Yes.
Absolutely, it would. Because if you renounce and you're planning on holding that U.S. asset, all right, you're setting yourself up for, a 40% tax on that if you die.
Yeah.
And by the way, listeners here, people may be thinking, well, John, that's so stupid. Very few people have assets on that level. Well, let me tell you about an asset that a lot of people do have. IRAs. Okay, this sort of stuff. Stock portfolios. These are also U.S. size assets.
Yep.
So, you really got to be careful here. And by the way, okay, this is not some 1-hour consultation with somebody, okay? This is a plan that you put time into to figure out.
And I usually give a plug for John at the end of the show if you're thinking of renouncing, but I think this is a really, really great illustration of how much thought and how methodical and thorough you need to be. What's the point of renouncing your U.S. citizenship to escape a horrific income taxes, to jump into a horrific estate and gift tax? So this is where you really want to think about every single possible
scenario.
Yeah, and it's really the scenario that a lot of advisors forget about is the final scenario. What happens upon our exit from this glorious world? So I think this is
it is. The other thing I would add, though, is, let's imagine that you're living in the UK and you have the equivalent $10 million asset in the UK. Well, then maybe you don't want to be a citizen, right? Because being a citizen subjects you to the estate and gift tax on your worldwide assets, right?
Yes.
So, this is like, I know you all, you're looking for simple answers, okay? And there are no simple answers, okay?
No, and that's why.
No, everybody's situation is different. And that's why it's, you need to sit down with somebody to really go over this plan, and it's going to cost to do it. And that's important for people to know, but it's important to do.
Exactly. And maybe right here could be my public service message, because one frustration, whether I'm dealing with people in the West or around the world, people right in my town, is this is a common thing that comes up. Oh yeah, I'm a beneficiary of a trust. I'm like, okay, well, look, we need to come with your plan. So, can you get a copy of that trust from your parents, or whatever? Yeah, they won't give it to me. They
Right.
won't.
Right.
And it just baffles me. It baffles me that, and it's a common thing that I run into, that these people will put a ton of money into a very exquisite estate plan and spend a lot of money, and then they'll be very quiet about it with everybody and make sure no one else knows about it. And no one, and this is the thing. When you are a trustee, a trustee has a job. When you're a beneficiary, you have a job as a beneficiary. What your job as beneficiary, to make sure the trust is performing. Did anyone tell you to do that? Did anyone give you a metric by which to measure if it's performing? Did anyone tell you where to go if it's not performing? How your rights are as a trust? And these are the things that drive me completely nuts in estate plannings, when families won't talk to each other. Well, you're going to give it, right? You're going to give them everything. But the thing you don't want to let them know is, hey, look, here's a general idea of what we expect. No, I understand. You might want to change things. You might want to, hey, look, this is the way it is now, but I might want to change things. Right. I think that's often the driver, but you got to give people a general clue of what might happen. And I think that's really go ahead, Keith.
Yeah, and that's what I tell people with whom I speak, that they need to sit down with their mom and dad, especially as an American overseas, and you need to know what's in their inheritance, what's in their trust, because it may need to be recalibrated based on your situation as an American overseas. But you got to have that sit down. There's no two ways about it. It has to be done.
Yeah. You have to get that conversation going. And I would say this too. It's like, and I would say this, hey, mom and dad, or if you are the person think about what's happening. Think about what we just talked about. We have every government in the world looking for their share of your stuff. And if you mess this up, there are terrible things. A 40% tax rate is possible. There's other situations. We won't get in every nightmare, but you could really lose a tremendous amount. And the whole point of these things is to create some sort of legacy security. Well, if you don't handle the tax part correctly, you could lose it all. And you have to understand, most attorneys do not do international stuff, and they will tell you something. They might be familiar with one thing, but they might not understand it, even think about it. You will surprise them. And that's why I'm saying, I do think, and I encourage a lot of attorneys to get into this field. It will be growing. And there's just not a lot of people who understand the issues and what comes up. And so that's something to understand. So even if your attorney could be a very good attorney, I'm not saying they're not, there might be something they don't know. That's all, just saying that. So you might want to get some second opinion. All right. So let's, all right, next slide here. All right.
We've talked about that.
We talked about,
Next.
Next, the cost benefit analysis for us. We got to do this. And this is what John does. And this is what we do with our clients who are renouncing again. So you got to get someone who really cares and looking at this every possible angle. Okay. Now we're talking about.
And don't forget, although this is somewhat different, okay, don't forget the covered gift problem, that if you were to renounce as a covered expatriate, the 40% reverse tax on U.S. person recipients of gifts or bequests, which is why a family that renounces together bonds together. But in any case,
okay, let me just get through this again. If you don't mind me just slowing down here. If a renunciation is a covered expatriate who makes a gift, okay, so covered expat is someone who is over the threshold amount, or it did not certify in 8854. Okay, so they're over an amount, which makes a gift or leaves a bequest to U.S. person. What? Wait a second. Oh my God. Oh my God. So you will be subject to a 40%. Oh my God. So I mean, there you go. And that is, do you see what happens by trying to avoid something you could subject by expatriating to avoid taxation? You could subject your kids to a much worse thing. And that's, again, why you got to be careful when you're doing it. And if you're going to renounce, as John says, renounce together. So the gifts that you're giving are to also people who renounce. That's kind of the thing. That's what you're looking to do. The FBAR marriage, this is basically what Keith's group is at Facebook group.
All right.
Yeah, go ahead.
All right. This is a very significant issue for multinational couples. By FR marriage, what I mean is the marriage between a U.S. citizen and a non-citizen. Now, where you see the bigger problem here is where you have a U.S. citizen married to a non-citizen, and the non-citizen dies, and you've got the problem of leaving the estate to a non-citizen or making gifts to a non-citizen. This sort of stuff. So if you have a good marriage, a clean marriage would be a marriage between two U.S. citizens. A clean marriage would also be a marriage between two non-citizens. But an unclean marriage would be a marriage between a U.S. citizen and a non-citizen. And you can further classify unclean marriages into dirty, filthy, and grungy. Okay, depending. The reason why this is a problem is because basically a U.S. citizen can make unlimited gifts, bequests, whatever, to a U.S. citizen spouse. But if the bequest is left to a non-citizen spouse, okay, the problem becomes, it opens the door to gift taxes and things like that, right? So, it's a real, just think about this if you don't know about it, and all of a sudden, there's a death, and that's a terrible time in people's lives and having to deal with this stuff as well. Now, this, I think, needs to be understood, right? If a non-citizen marries a U.S. citizen, this is an issue. It doesn't mean that it can't be dealt with. It can, but you got to know about this in advance. Under the Internal Revenue Code, you can deal with it with what's called a qualified domestic trust. There are also larger annual limitations on gifts that can be made. They're about 190,000. You make a gift to a non-citizen spouse that's more than 190,000, it would go against your lifetime 15 million. Right, so it is possible, but it's reportable.
That's right. Yeah, and this is this is the unclean marriage. It does happen. We have a lot of unclean marriages as clients, and Keith's group is extensively full of unclean marriages. And look, we're not really the ones qualifying that. We're sort of implying what the government is considering your marriage, and that's why you
right. We don't think it's unclean. It's just the way.
No. We believe your nuptials are honorable, but the government believes you to be unclean and deserving of special punishment. All right, so let's get to the next one here. All right, foreign assets and gifts by other countries. Yeah, this is another thing. They like to do this, right? They like to. These other countries like to tax things. I'll wait till you get this. So okay, so this is the issue. This is the issue that we need to get to. Is like, well, are you being taxed on the same things around the world? Now, is this for to? I guess the thing is, like, we have these income tax treaties, and they said to avoid double taxation, which it really does.
We're not at the treaty level yet. Okay. There is a provision in the Internal Revenue Code that allows a tax credit. Okay, so that's all I wanted to say. All right, we don't have to get to the treaties to necessarily, resolve the double taxation issue. Maybe yes, maybe no.
And so essentially, there doesn't need to be a treaty to get the credit. That's which is important because there's not gift and estate tax treaties with every country. So
yeah, right.
You will still get the gifted. So all right, very good. So now John, these are all of the gift tax. These are all of the U.S. tax treaties, right?
Yeah, and there's a difference between gift and estate tax treaties.
Oh.
Okay. Some of them are. With some countries they're both. With some there's one. There's some another. Right. And in Canada, it's not even a separate treaty. It's incorporated into the income tax treaty.
Yeah. Okay.
But there really are very few of them. Yeah.
Right. There's really not a lot. So there's something else here. All right. So now, all right. And okay. So explain to me how these can help.
Well, they help the same way. The way tax treaties work in theory, right, is their purpose is to avoid double taxation, and they do it either through a tax credit mechanism or what's called an exemption mechanism. In other words, if it's exemption, one country just agrees they won't tax it. If it's credit, they both tax, and there's a credit paid against it. But I mean, it's not really dissimilar from the avoidance of double taxation and income tax treaties. But that's how it works anyway. They're a lot shorter, by the way, in general. They're not like these long things.
All right, excellent. All right. Oh, there we go. Right. Hey, look at those guys. Hey. Right.
Now, here's the point that needs to be made here, okay? There's a feeling, okay, that income tax treaties are pretty similar. All right, most of them follow the OECD model tax treaty or the US model tax treaty or something like that. That is absolutely not the case with the state and gift tax treaties. They vary widely. And another reason why they're different is because, I mean, not all countries have estate taxes, but they may have an inheritance tax, right? That in effect creates double taxation, even though it's not double taxation because of two estate taxes. And for example, Ireland, all right, would be a country that I think they say they have an estate tax treaty, but Ireland doesn't have an estate tax. They have an inheritance tax, right? So these are treaties that are essentially designed to avoid double taxation when somebody dies. All right, regardless of the type of tax it is. So that's what they are.
So, and I think this is the important question that I have is that, so if, let's say that actually I have Japan up. I have that article that you put in your presentation. Let me just add this one up here because I think this is a great explanation of sort of a competing difference between how other countries do it. So this is a podcast John shared. I'll put this in the super chat if anyone wants to check it out on your own. But this is a really good explanation of totally how Japan's completely different. So Japan has, unlike the United States, it's an inheritance tax. It's not an estate tax, meaning the recipient has to pay the tax. Now, this is where it gets confusing because certain U.S. states have inheritance taxes too, but the United States government, the federal government, does not have an inheritance tax. So that's number one. And then number two, how the exemptions work, it's more on a per heir basis. That it looks like something like this is that you multiply your basic exclusion amount is 30 million yen, and then there's a formula to figure out how much will be exempt. And then from there, there's maximum rates, and here too. And then as we go through here, Japan will also sort of like, you just can't leave today and say you're done. You're like, well, we're going to follow you a little bit. So here's a great example of how the Japanese inheritance works is totally different, but that the treaty can still help out, even though you can use a credit for an inheritance tax to offset an estate tax. Does that work, John? That's my question.
So all this is just an example of, one way of mitigating it,
Okay.
and they're all very, very different, right?
Yep. All right,
I mean, I don't think there's any point in really getting into the details.
No. I just basically like it can look, just because they have a different, one has an inheritance tax, one has an estate tax, it doesn't mean you will be shut out of the credit. That's the important thing.
All the way to think about this stuff is, okay, when people die, countries have taxes, okay? Generally, to get their, their share of the take. And some of them are estate taxes. Some of them are inheritance taxes. Some of them call themselves inheritance taxes, but they're really estate taxes, like in the UK. Some of them are disguised income taxes. All right, it's impossible to generalize. All right, but what the key point here is that these are just mechanisms so that, the beneficiaries of the estate can retain some of the assets. That's all this stuff is. And they're not easy. Okay, they vary in their degree of difficulty. I'm not necessarily. I put up those links, for interesting commentary on those things. I'm not, obviously I can't guarantee the commentary is even correct. All right, because it's only as good as whoever put the thing together. But that's not really the issue. The point here is that when we're dealing with foreign assets, all right, there are mechanisms in place in the form of estate and gift tax treaties that prevent double taxation or mitigate it. That's the point.
Okay, and I have and I'm going to put this. Here's we have a lot of clients in the UK, a lot of interest in the UK. I'll put this. Here's the UK's double taxation relief of deceased person, and so here, it's got an interesting name, right? So 1979. So here we go, and here's the entirety of it. Here, right? This right here is just the preamble to it. Not a lot here going on. But here, so here, basically starting here, Article 1, and that is it. That is much shorter, even though it's long. This is much shorter than a typical tax treaty. So that's what we have here. So that's the UK one. And now we have Australia. All right. Anything you want to see here? We got USA applies to U.S. status assets. And what here? If your worldwide estate exceeds its threshold, U.S. estate tax could apply at rates of 40%. Whoa.
So, Anthony?
Yeah.
All right. I actually have to leave in a minute because I'm getting thrown out of this place.
Right.
So, you can, I've said really all I have to say.
Fantastic. All right, great. Well,
other than this, I know that everybody's looking for, a quick fix answer. Don't be an idiot. Okay. This stuff is even on the level of the U.S. domestic law, it's complicated. But when you start adding this other stuff in, it becomes a lot worse. Potential for making mistakes is huge. And I strongly suggest that people, get the kind of help they need on this.
Very good. Thank you so much, John. Thanks for chumming on your busy travels. Thank you so much for making it this morning for us because we really needed it. So I appreciate that, John. And you are thinking.
All right, so
reach out. I'll let you go, John. Thanks so much. Right on. All right, Keith, my man. So you have to leave too soon. So I'll answer all. So I'll get to the audience questions.
I got to leave in about in 3 minutes.
You have to hop off too. So I mean, this is the common thing. I mean, this is happening more and more. I mean,
right. So that's why I do what I do, and people who need to have some just top line guidance as far as their options, they can contact me, and we just kind of go through that vis-a-vis their inheritance and what they need to do is possibly recalibrate it. And, I deal with a lot of people who have either never been in the U.S. tax system or haven't been for many years. And depending on their situation, they may have to enter the U.S. tax system or quote unquote re-enter it. And it just depends on their situation.
And Keith, I think you feel such a valuable function, and your group is growing. You just went over 12,000. Congratulations on that. People put American expatriates, but really, the thing is that and this is the problem that I have myself, and and as we just experienced with John, is that as attorneys we often speak way over people's heads, right? And so you're really able to say, hey guys, here's really what you need to do. And so I think you really have that human touch, right?
Yeah, just to kind of assuage the fears. And I always say there is a solution. It might take time, but there is a solution, but you need to have a plan, a short-term and long-term strategic plan.
Right on. Yeah, absolutely. So I know you're going to hop off. So I just do want, if people want to reach out to you directly, they can email you right here. Hey, look, thinking of renouncing, I have an estate plan, I have a gifts issues. Reach out to Keith. He is, and this, I think you're going to get, I think you're going to be busy for a bit here, Keith. You're going to get busier and busier. So reach out to him at US_overseas_advocate@outlook.com. And if you are on Facebook, check out his group, American Expatriates. It's growing. And it's not to answer tax questions. There's other groups on Facebook, US expat tax questions.
Right. That's to answer specific tax questions. That's not what this group is about. It's about supporting residency-based taxation. And it's also supporting those who really need to take a look and explore their options.
That's right,
based on their particular profile and situation.
Well, I would say too, you're more about the whole lifestyle. There's like a particular technical tax questions. You're more about here's the problems I'm having as an American overseas.
Right,
And
right.
there's multiple. So, all right. Well,
And the red flags to take a look at and
there
so
you
forth.
go.
Absolutely.
All right. Well, thanks. Please reach out to Keith Redmond. Thank you so much for joining us today. And Keith will be coming up to Connecticut on Monday. So looking forward to seeing my man. He's traveling through New England on Monday, so he's going to stop by and say hi to me up in Connecticut. So it's going to be a lot of fun. All right. So Keith, thanks so much. And now let's get to some comments. All right. I'll see you. All right. Who's in with us today? Professional of Stuffology. Good morning to you, my man. Right. Yeah. And so here's sort of the thing that was going through my head, Professor of Stuffology, is that we have a fundamental right to inherit our property, right? We have a fundamental right. Government shouldn't interfere with our fundamental right to enjoy property. But what's the first thing they do? Is they interfere with our fundamental right to property by taxing it. And the real problem that we have here is that the governments have been allowed to just sort of take, and there's a presumption, and culturally, and I would say this very culturally with the baby boomers, and I love you guys, but you guys are so programmed. You are so programmed by things, and you still believe so much of the mythology of this government. So we really want to get to a point where the government doesn't have a right to our stuff simply because, what we need to get to is a tax system that taxes us based on what we used, not because of our mere possession of something. And that's really something that's the big premise that I think we have to get around. Now, Professor of Stuffology, you have another great question here. And I actually don't know the answer to this one. Is probate court a court of record? And probate court is probably something I could cover a lot more. In law school, I would say this: probate court was sort of the ugly stepchild. I didn't make it onto law review. But I could make it onto probate law review, right? So the answer to the question is probate a court of record. Well, historically, it has been. I do know that probate courts are set up by statute, so I'm sure there are some, unconstitutional things that happened in its creation, but it has been doing. And can the people enter into any compact or treaty that abrogates property rights? Well, no. And that's the thing. This is actually the point of it. If you say no, your right to enjoy your property is a fundamental right. And what it also is it's inalienable. And that means even if you vote for a law to take away your right, you can't. That's what inalienable means. And so we miss out on the fundamentals of so many things going on here. Let's see here. What else we got here? So can you retain rights? Yes. Oh God, we got this. All right, Professor of Stuffology. All right, we're going to get into some heavy things here. I'm not sure if we want to get in there. This is what we're trying to get to. And this is where I'm going to see, this is kind of where I see all of tax going to. And this is where I'm, coming to professionally myself. Is that, I went through the whole law school programming combine. And it was programmed. There's a program that is all there. The program will tell you a few things. Number one, worship the federal government. A strong federal government is a good thing. A weak federal government is a bad thing. Why is a weak federal government a bad thing? Because people have too many rights. So law school will always tell you a strong federal government is a good thing, and that they don't really necessarily tell you strong government means that the people are weak. That they don't tell you that. So it's all this to get you, hey, get on the bandwagon. Hey, support the cult. We're strong. This cult doesn't deliver anything for you, though. You're only working for the cult. It doesn't give anything to you. So that where I'm going now is that, and this is sort of to give you the whole framework of where I see the law developing, and I'm commenting on this, is that number one, we have seen some huge changes from the Supreme Court. And I mean, I'm still in shock by things that happened. Number one, Chevron deference went away. That was in Loper Bright. Chevron deference went away. Not that big of a surprise, I guess. Maybe, hey, we're not going to defer to agency interpretation anymore. That's what Loper Bright says. But some other cases are far, far more shocking and broad-reaching. One of them, we have Jarsky versus SEC. There, the Supreme Court says what? It says, yeah, your entire administrative law tribunal is illegal. Doesn't count. You're suing on a common law theory. You got to use the law. You have to use the courts. You can't use your administrative agency. Shut down. The SEC basically shut down. We also had the Department of Labor shut down in Sun Valley. That's a Third Circuit court that was shut down. Say, you guys can't do this. You're trying to basically sue on a common law theory of employer-employee relationship. You cannot use your administrative tribunal. Shut down. So the question is, let's see here. The administrative, let's think about this. The U.S. Tax Court is an administrative court. It's not Article 3. The same reason why the SEC, Department of Labor, EPA, all these administrative tribunals are illegal is the same reason tax court's illegal. So here's the problem for the government. If Supreme Court finds that the tax court is illegal, there's more difficulties for the IRS than you could imagine, because part of the whole tax court game is the presumptions and how the presumptions work. Under the common law, the person accusing has the burden of proof. But if you look at how the IRS has their process, they flip it. They flip the presumption. You end up as a taxpayer with the burden of proof to prove what the IRS says isn't true. And that same presumption travels up to tax court. So now what would happen if the IRS was treated like any other litigant in civil litigation? What would happen? Well, they would actually have to prove their case. They would actually have to prove their case. And then you would be able to sit there and shoot it down like, no, you're wrong about that. You're wrong about that. You're wrong about that. And effectively, it would be the end of the IRS. The IRS as we know it, this massive monster where notices of deficiency are reviewable by the tax court, it's going to end. And that is actually the true thing that could happen. And the tax industry, as far as I can tell, isn't paying attention to it whatsoever. The tax industry, as far as I can tell, they're focusing more on the one big beautiful bill. They're focusing more on the political aspect of it. I'm not interested in the politics of it whatsoever, because it's always the same thing. We always get the same thing. We have we get bipartisan support for the most complicated laws possible that no one understands, reads whatsoever. It's not representation. We don't have any representation. So I'm not going to really focus on what's happening in the laws, because it's always going to be manipulation. It's always going to be interference with our fundamental rights. That's always what it's going to be. It doesn't matter, Democrat, Republican. I'm really, really interested in what will happen with tax court and what will happen with the administrative agencies, and that's where I see a lot of this going. But now this is the other part of it, though. While I see the IRS going away, I do not see estate taxes going away. The state and gift taxes of states and the federal government goes away. I don't see that necessarily, because that's just too much money for them to say no to, and historically they've done it. So I see perhaps income tax becoming more simple, because it has to, because without tax court, the IRS will have no choice. But at the same point, because of the massive amount of wealth, because government is so greedy for other people's things, they're not going to be able to say no. And so these are where I think the bigger issues are going to be coming up over the next few years. So that's kind of where I'm at, Professor. That is kind of where I'm at on all of this, is that it's all coming to an end very shortly. It's going to be very different, but this massive wealth transfer is happening, and that's where a lot of attention needs to be put. Now with that, I am gonna we are gonna be covering some more things next week. Always, and this is what I suggest to people: if you have a topic you want us to cover, you can always email me. You could always email me directly at aparent@irsmedic.com. I would say this, and I want to thank John and Keith so much for their participation today, and I want to thank you, because really this channel does attract a unique sort of individual who is incredibly sharp, pays attention to things, and your observance of things really helps me be a better attorney and a better person as well. So I really do appreciate that. So if you do have some content ideas, and if you have something you want me to cover, you could just email me at aparent@irsmedic, or you can follow me on Twitter. Lots of discussion going on there, especially on the common law, if you want to really get a good idea of what's happening, the developments. And look, the people are assembling. and it's not me leading this. I'm jumping on board the bandwagon. There's been people joining the common law movement to reclaim our fundamental rights. And I'm one of the few attorneys, I think, who understand that. Because again, the law school programming is a way to sort of make it look like statutes are more important than the common law. Constitutions are more important than the common law. That's actually not true. The common law is what the Constitution was promised to protect. And we could the government wants to ignore this, and the government wants us to not know and understand where our rights come from. We did see that debate last week. I think it was a Jerry Nadler, or no, it was some other U.S. representative, and I had to think, it was Tim Kaine, the 2016 vice presidential candidate. If you forgot about that, it was Tim Kaine who spoke that he basically recited the entire law school sort of brainwashing. Or it's not brainwashing, but law school gave you two choices. Where do our rights come from? Do our rights come from God? Well, law school can't stand God, right? Law school doesn't want anything to do with God. So the other alternative is it comes from the government, but we're not going to say that. We're not going to say that. We'll just say it comes from traditions and government or whatever. And those are really your two choices. And so we saw Tim Kaine basically say that, basically repeat that lie. It's a lie. No, rights don't come from the government. The U.S. Constitution wasn't this document to say, thank you for giving us our rights. No, it said, hey, our rights come from God, and the purpose of government is to protect our fundamental rights. Our fundamental rights actually come from Jesus Christ. That's actually the evolution. It's not just God, but really the common law is a direct consequence of the gospel of Jesus Christ. And when you understand that, then you understand what the U.S. tax code's all about. What the U.S. code's all about is to deny us our humanity. So I am going on a little bit on that. I'm about to wrap up here. Who else? So sharp guy. I think so. But I'm only sharp because of you guys. So please keep me honest, keep me going, keep those topics coming, and let's keep the discussion going. This is Anthony Parent. If you do want to reach out to me, we do a lot of tax work internationally, especially. We do a lot of tax planning, tax prep too. We do a lot of that. So if you have this issue, we're doing a lot of streamlined disclosures right now, getting a lot of people ready to inherit, and then a lot of people ready to renounce. Those are sort of the two paths people are going to. Hey, I need to renounce because I'm going to inherit. I need to renounce because of for other reasons. So we're seeing, or I need to get it streamlined because I would just need to be in compliance. And so that's what we're seeing a lot of right now, having a lot of fun with some great clients around the world. Sherry, good morning to you. Good morning. Thank you so much for joining us, Sherry. Thank you. Good morning to you. All right, that's it. This is Anthony Parent. See you next time. Signing off.